Hello and welcome to Pensions in a Pod, a podcast series by Evershed Sutherland that keeps you informed on topical issues within the pensions and benefits world. I'm Jeremy Goodwin, partner and head of pensions, and in each episode within this series, we'll hear from speakers across our pensions and benefits team.
Hello everyone, welcome to the August edition of Pensions in a Pod. My name's Emma King and I'm going to be chairing today's episode. So what's trending in the world of pensions right now? What should be on your to-do list? Well, I think the top three items are firstly, the new DB funding code, and that's going to come into force for valuations with effect from the 22nd of September. And then number two is ongoing preparation. And under that, I'd include general code of practice and dashboards. And yes, I know I slipped two in there. And then thirdly, the one everyone is talking about, the Virgin Media case and the need for actuarial confirmation in relation to historical benefit amendments for those DB schemes that were contracted out on a reference scheme test basis. And that's what we're going to be focusing on in today's episode. And I'm delighted to be joined by my colleagues, Richard Bacon and Stuart Earle.
Hi. Hi, Emma.
Right, Richard, can I come to you first? I think it might be helpful if you gave our listeners a brief reminder of the background to this case and maybe where we are now.
Absolutely. So this was a case before the Court of Appeal, and judgment was handed down in July of this year, 2024, if you're listening to this in many years to come. And I don't think it's an overstatement to say that it's possibly the most significant pensions case of the past 30 years. And we act for the scheme's trustees who took a neutral position as to the outcome. And it concerns very broadly amendments to final salary or defined benefit pension schemes. Technically, we're looking at something called contracted out salary related schemes, but broadly, that would have been the majority of final salary schemes at the time. And it's about amendments that meet two criteria. Firstly, amendments made between April 1997 and April 2013, although the case is also relevant to certain amendments made all the way up to April 2016. That's nearly a 20-year period. And secondly, changes to something called members' Section 92B rights. And again, very broadly, that's their substantive pension benefits provided to members and their spouses under those schemes, although there are a number of exclusions for things like money purchase and discretionary benefits. And this case focuses on, as you mentioned, Emma, a very specific legal requirement, which is that before the trustees of a final salary scheme made those amendments, they had to obtain prior written confirmation from the scheme's actuary that after the changes were made, the scheme would continue to provide benefits of a certain standard. And that's called a Section 37 confirmation, to use the technical language. And the question before the court was, fairly simply, if the trustees didn't comply with that requirement, so they didn't obtain that prior written confirmation from the scheme's actuary before a change was made, are those changes still valid? And taking the outcomes at the High Court and Court of Appeal levels together, the overall impact is that where trustees fail to comply with that requirement, the changes will be void. And that applies to all changes, including both benefit reductions and benefit improvements, and both backwards-looking and forwards-looking changes. And it's a very, very significant decision.
Yes, significant indeed. And I know it's one that everyone is talking about. Stuart, can I bring you in now? Maybe you can outline for us the potential implications for schemes. So, what's the impact here? And is the government going to come to the rescue here and fix it?
Yeah, thanks, Emma. So I think the extent of the impact of the judgment will vary scheme to scheme, as one would expect. And it very much comes down to when the scheme was contracted out, what, if any, changes were made to the scheme's benefit structure, and importantly, how those changes were implemented in practice during the relevant period, as Richard's outlined, 1997 up to 2016. So if, for example, and as was particularly common in the late 90s, early 2000s, defined benefit scheme moved its accrual rate from, say, a 60th to an 80th, or perhaps moved from final salary to career average as a way to reduce the cost of providing the defined benefit, Virgin Media has now confirmed that a Section 37 confirmation would have been required for those future service changes. So without that confirmation that the scheme benefit structure continued to meet the reference scheme test, those amendments which might have been made 25 years ago could now be considered to be void or at risk of being void. Now, the big impact there, of course, is whilst the scheme might have been continued to be funded and supported on the basis of a reduced benefit accrual, maybe because of reduced accrual rate, perhaps a capping of pension increases, those changes are void. Schemes and corporate sponsors could be looking at a not insignificant increase in liabilities. The other one to bear in mind, of course, is that in the late 90s, early 2000s, many schemes were still closing their barber window because of unequal retirement ages. Now, if any amendment to close the barber window wasn't accompanied by Section 37 confirmation, there is a possibility that that barber window might be creaking open again. So there are a number of areas to consider and potentially significant financial implications for schemes and corporates. As to whether we can expect a fix from government, well, the industry has certainly been flagging this to DWP since the High Court decision in June 2023. There are conversations. We know there are instances of evidence and description of the type of issue and potential quantum of risk being put on the table with DWP, so they have the full picture. Importantly, there is a clear provision in Section 37 itself, which enables regulations to be put in place, which would operate to validate retrospectively alterations to scheme rules, which would otherwise be void. And so it's not as though we need primary legislation here. There is a regulation making power that envisages retrospective effect. And so I hope that, depending on the information and evidence put forward from discussions with DWP, that some input and some output from DWP can be expected, but we don't know. It would be useful to the industry to have clarity on that sooner rather than later, but we're still in that holding pattern.
Thanks, Stuart. I can certainly endorse the fact that either way, it would be useful to know sooner rather than later if we are going to get a fix or not. Richard, so we've heard what this means potentially to schemes. What do you think both schemes and their sponsors should be doing now?
Well, there are a number of approaches which could be justified. On the one hand, this is now the law, and it's arguable that trustees and sponsors should be looking at the way that the case might impact on their schemes, and the need to do that could be driven by requests from scheme and corporate auditors, as well as insurers. On the other hand, some parts of the industry are supporting a bit of a wait-and-see approach on the basis that there could be further developments, and in particular, that possibility of the government introducing legislation to reverse the effects of this case. But as Stuart mentioned, the timing and scope of any further developments is currently a bit unknown. So trustees and sponsors are going to need to take a risk-based approach, but practically we can see the argument for reviewing how this case impacts on a scheme now, and that's particularly the case where limitation periods could be an issue. And what do I mean by that? Well, under English law, to slightly simplify the position, there's a 15-year long stop for bringing claims against professional advisors in respect of professional negligence. And that's relevant because if this is an issue for a pension scheme, and there were changes to the scheme from mid-2009 onwards, which could be void, trustees and sponsors might need to consider taking steps to protect their position in respect of claims against their professional advisors, because that 15-year long stop limitation period for bringing a claim could be about to expire.
Salient words, thank you. Interesting you mentioned auditors, Richard. I'm already seeing auditor involvement, particularly for sponsors with year ends in the early autumn. And they certainly seem keen to inject some certainty into the position. My concern is that by looking, you might actually find that you make the position even more uncertain if you've got any missing confirmations. Stuart, by contrast, I know a lot of people are wondering whether it's okay to do nothing at all and wait potential developments. As Richard alluded to, some people are thinking that. I guess it does all depend on the scheme's history, current position, and appetite for risk.
Yeah, I think that's spot on, Emma. We're sort of in this position where there is a potential for further legislation. We don't know what further developments may come of this in years to come. I suppose it took a while for schemes to settle in after the Barber judgment all those years ago. I think your point about where schemes currently are in terms of their existing position is right. For those schemes which are about to enter into a risk transfer transaction, a buy-in or buyout, for example, then this will understandably have to be on the radar and have to be something that is looked at in order to establish what liabilities are being covered and where there is a risk of future comeback or future liability that may in itself ultimately fall upon the sponsor. And in terms of the sponsor itself, if they're about to enter into any corporate transaction, corporate activity, where there's a defined benefit scheme involved, then due diligence on the scheme will be a material factor, and understanding the position around Section 37 confirmations will be key to that. Similarly, if there's a bulk transfer in the offing between pension schemes, again, understanding the risk of any legacy Section 37 confirmation issue will need to come to the fore. I'm talking to a number of pensions managers, chairs of trustees, finance teams. There is an element of, well, we would like to know if we have an issue, but do we look? And there is an element of this being the pensions industry Schrodinger's cat, perhaps. But ultimately, I think where you're in a position that you're about to do something with the scheme, looking at this and understanding of the risk is undoubtedly going to be a necessary step. And as you mentioned, Emma, the role of the auditor may well actually take this decision out of the hands of the trustees or maybe finance directors, because if the auditors require confirmation and input on Section 37 position, then with the best will in the world, taking a pragmatic view and waiting for developments might not be possible in the next sort of 6 to 12 months as we reach those accounting disclosures.
Yeah, absolutely. So yes, transactions, mergers, risk transfers, all of that, I would have thought is going to need you to think very carefully as to whether you look. And certainly if trustees are looking to sponsors to indemnify for any potential risk, aren't sponsors going to need to know the extent to it of the risk to which they're indemnifying?
Exactly.
Yeah. Richard, can I come back to you? So let's presuppose here people are starting to look. Can you give us some practical tips about what you might look for in terms of evidence of actuarial confirmation if you haven't got that neat Section 37 certification appended to your deed?
Absolutely. So a lot of the documents relating to these issues are clearly going to be very historic, and many of them will be in hard copy. And I think the key thing at the moment is document preservation. So many corporates have automatic processes for destroying documents after a period of time, and that makes sense. You don't want to have warehouses of old documents sitting around forever. But where this case could be an issue for a pension scheme, trustees and sponsoring employers and also professional advisors should be taking steps to preserve potentially relevant documents and ensure those documents aren't being destroyed in accordance with those automatic processes. But a key thing to emphasize is that the legislation doesn't require a formal certificate from the scheme's actuary in relation to proposed amendments, but rather just prior confirmation in writing. So where a formal Section 37 certificate can't be located in respect of changes to a scheme, it'll be worth looking for anything that either, firstly, could constitute that prior written confirmation in itself, and that could be, an exchange of emails between the trustees and the actuary. Will the scheme be Section 37 compliant after this change has been introduced? Yes, it will. Or secondly, anything that evidences that the confirmation was in fact given, but now it's just been lost and can no longer be located. And that could be something like a recital in a deed saying that the confirmation was provided, or could involve looking at trustee meeting minutes as well. It could, in principle, also include something like a witness statement from the scheme's actuary about their general practice at the time, or even confirming their recollection that prior written confirmation was given in respect of a specific amendment, although it might be perhaps surprising if memory could now stretch back 20 years, although you never know. But whether that evidence is sufficient is, I'm afraid, going to be a very fact-specific exercise in relation to each scheme and each invalid amendment. And that's going to require quite careful consideration between trustees, employers, and their legal advisors. And I think in some cases, you might also need a court application for a definitive confirmation.
Good. Okay, well, that's a lot of helpful, practical advice there. And I mean, I've certainly been delving in some cases back into archive hard copy files and have been finding the relevant certifications. So it all is not lost necessarily. So if I could come to both of you for one final thought. Stuart, can you go first?
Sure. Look, I think I'd just go with don't panic. Make sure that this is on the agenda for trustee boards, discussions with the company. And if a decision is taken at this time not to review legacy files, make sure that you've got a clear note as to why that decision is being taken at the current time.
Thanks, Stuart. Richard?
I would just add that this is an area where there's clearly going to be a lot of further developments in the coming months and years. And that could be in the form of further hearings, further cases, and as we've mentioned, potentially new legislation as well. So watch this space, keep on monitoring, and keep on listening to this podcast.
Thanks, Richard. So, I mean, my take on this is there's actually no right or wrong answer here, and it's all very, very facts specific and scheme specific. It depends on your circumstances. It depends on the sort of projects that you've got ongoing. But certainly, keeping close to developments is going to be key here. Thank you all for listening, and do tune in again to our next episode due out in September. Bye-bye.
Thank you for listening to the latest episode in the Pensions in a Pod series. Stay tuned for our next edition, where we will provide more perspectives into the world of pensions and benefits.